And everyone who's joined us today, thank you so, so much. So I'll go ahead and introduce everyone. So I'll start with me. For those who don't know me, I am Lisa Taylor, half of the team leader for the TaylorMade team. We are based out of Upper Marlboro, Maryland, and we have about 12 people total on our team. And just a little bit of background, this idea came about, and I shared with the people who joined us earlier. It came about because we actually are going through this process because we actually have a house on the market, and one of the owners died 3 days before closing. So our team was curious to know, how do you handle this process? So this was where this idea was born. And instead of just sharing it with the team, I want to share it with all my fellow colleagues out in Realtor World. I want to also introduce our main guest speaker, Ms. Shakisha Morgan. Shakisha Morgan is an estate planning and probate attorney with the Griffin firm. She is a Stanford and Georgetown law graduate. So yes, girl with the brains, go ahead. Love Georgetown. She's also an attorney, advocate, and educator with a decade of legal experience who uses values-based estate planning strategies to empower individuals and families to create, protect, and transfer wealth. So she's going to be a gold mine of wealth for us today. And also we have Jamar Patterson. For you guys who don't know, Jamar Patterson is the managing attorney with the Mason Law Firm, which is also based in Upper Marlboro. He joined the Mason Law Firm in 2011. And prior to joining Universal Title, he served as a law clerk to the Honorable James Carroll in the Superior Court of the Virgin Islands. What made you come here, Jamar? You left the Virgin Islands to come here. We also have on here Ms. Margaret Davenport, who's the Director of Operations for the TaylorMade team. In her prior life, she worked with the World Bank, and she took a leap of faith and decided to jump headfirst into real estate, not knowing what she would get herself into. And I'm glad she took that leap of faith. And the other day she told me she's happy. Is that true?
I'm absolutely happy.
Yay! I thought you were going to say something else, because then that would have been a good look. And last but not least, we have a surprise guest, Mr. Donnell Taylor, who is my husband. In June of this year of 10 years. I can't believe it. We made it to 10.
Oh,
yes. I'm so excited, Mr. Taylor. But he helps me run the team. He is my right hand, and I so appreciate him for being with me on this journey. So let's go ahead and get started. And we'll start off with Ms. Shakisha. And just a little bit of housekeeping, everyone who's joining us. Please put any questions you have in the Q&A box. You'll see this right at the bottom. And if you just want to comment, give a shout out to the team, just put it in the chat. So Margaret is monitoring the Q&A box, so that's how she knows if anyone has any questions or anything while we go through this little informational session. All right, Ms. Shakisha, I'll just jump right into it with questions. Are you ready, ma'am?
So I'm ready.
Okay, great. So just the first step, what are the first steps that an individual who wants to sell a house that does not belong to them and needs to sell it, what do they need to do?
All right. So very first step is to secure legal authority. The very first step, it's the most important step, and you can't do anything unless you've got legal authority. And depending on what the situation is, how you get that legal authority looks a little bit different. So let's say that you're the person's home that you need to sell, that person's living, but maybe incapacitated. That means you're getting legal authority either because they have a power of attorney that they've already properly executed, or through something called the guardianship process, and that's a legal process. Or if someone has passed, then that legal authority is given because you're going through the probate process. So either way it turns out, you have to get legal authority. Now, if this is legal authority because someone's living and they're incapacitated and so you're acting on their behalf, let's say you have a power of attorney document, financial power of attorney document, then what you're doing is you're recording that document first. And then after that document is recorded, now you can do what's necessary in terms of selling the home, transferring title of the home, whatever sort of thing you need to do. Now, here's an important thing. If that home is in the District of Columbia, you need to make sure that in District of Columbia, there is statutory language that has to be at the top of the power of attorney, before the name, before all that kind of stuff, it's right at the top. If it's a standard statutory form that someone got from online and filled out, you got to tell them, I can't use this to do it, all right? Because it's got to have that statutory language. And those standard forms that you download off of the internet don't have that statutory language. If the home is in Virginia or Maryland, I'm obviously talking about all the local stuff, then it doesn't need that statutory language. But if that property is in DC, there's certain statutory language. So in order to make sure it has that, if it's a DC property and someone comes to you with a power of attorney, ask a lawyer friend to make sure that it's got the proper language for you to be able to do what's necessary on behalf of that person, okay? If the person has died, all right, and now you need to get the legal authority, somebody's got to go to court, all right? Hate to break it to you. I love to be at court. I don't know if anybody else loves to be at court, but somebody's got to go to court, and they got to get that legal authority. So that means if there's a will, then the person who's named in the will, nominated in the will to have that legal authority, that's who goes to court and gets that will enforced. If there is not a will, then it's usually the closest kin, the next closest kin. So it's either a spouse or adult children who now have the most senior priority to be able to go to the court and say, I need this legal authority. And that legal authority is through something called letters of administration. So if you have a house that you need to sell that does not belong to you, you got to secure legal authority first, because without that legal authority, anything you do, even if, say you do sell the house, 20 years later, there might be unclean title issues that are coming down the line. And as a real estate agent, right, you don't want to be liable for not making sure that someone has gotten that legal authority, because if there's an issue, they'll come back to you and say, hey, you didn't tell me that I needed to do X, Y, Z. So that's the first step. Get that proper legal authority.
Okay, which is typically the letters of administration.
Yes, if someone has died, letters of administration. If it's incapacity, it's either power of attorney or you get that legal authority from the court through the guardianship process.
Awesome, awesome. And one thing I definitely want to touch on, because that's what we're dealing with now, how does the impact of having a will or not having a will affect this whole, estate and probate process? Because what we're dealing with is the person who died while we're trying to sell the house, they did not have a will. So that'll be great information to share.
Yeah. So look, a will, the beauty of having a properly executed will. So it's got to be all those things, right? It's got to be valid. And in order to be valid, it's got to be properly executed. So if someone brings to you a will that doesn't have a signature on it, that's not a properly executed will. If it doesn't meet the legal requirements of the jurisdiction, it's not properly executed. So if it's a valid will, the benefit of having a will means that the person who has died has decided who's the person who's managing stuff for me. And so if it is a situation where, say, somebody is single, they don't have any adult children, they can name any adult that they want. So it could be, I could decide Jamar is the executor of my will. And so that means that, when I pass, Jamar takes my will and says, all right, Shakisha nominated me, so now I'm the one that needs the letters. But if I pass and I don't have a will, then that means that depending on where I live, DC, Maryland, or Virginia, there is a priority order in terms of who can be the one who goes to court. So I'm a Maryland resident, so if I pass, I don't have a will. Right now, I don't have any adult children, I have minor children, so the priority is my husband, who would be able to go to the court. But let's say my daughter was an adult. It'd be my husband or my daughter. And hopefully they don't have issues and they're not arguing with the court about which one of them should be the one that's got the authority. So the beauty of having a will is that the person who has died has already designated this is who the person should be. And hopefully in that will, they've also designated a secondary person. That if this first person somehow is incapacitated or has died themselves, then here's the second person who I would want to be the one that goes to the court. So that is the beauty of having a will. It decides whether you've predetermined who that person is that goes to the court. You choose anybody you want, or whether the jurisdiction tells you this is who has priority, because if it's somebody, let's say Jamar wants to do it, but I died without a will. Jamar's got to get permission from my husband to bypass his priority in order to do that. And, you know, I don't see that happening. My husband's going to be like, I'm sorry, what?
So just to make sure there's clarity. So what you're saying, like if there's a will, right? So the person who has been nominated in the will, the process will be easier for them to go ahead and get the letter of administration, right?
Much easier. Yes. Yes. Okay. Much easier. Mm-hmm. Okay. Because all they have to present themselves.
And the will.
I'm the person nominated in the will. Here's the will. Well, and the death certificate. So help me, court, by enforcing this, by giving me the legal authority. If not, then you got to check the law to see who's got priority.
Okay. And I know there's something about posting notices. Does that affect this process as well? Can you talk a little bit about that, how it relates to if you don't have a will and you have to go through those, what you said, I guess the power of the kin steps?
Mm-hmm, mm-hmm. Yeah. Well, here's the thing. When we talk about probate, probate is a whole process in and of itself. And probate has some necessary steps in the process that happen whether or not there's a will. The benefit of having a will is it helps to manage that process and make it a little easier. So generally the probate process starts because somebody comes to the court and says somebody has passed. You got to have a death certificate. You got to fill out a petition. Sometimes you have to do a bond, which is like an insurance policy to make sure you do what you're supposed to do if you're appointed. Put that petition in. The court gives you letters, and then there's certain things that you have to do. You have to publicize that that person has died. And by publicizing that that person has died, the point of it is that once you're appointed, your job is to manage someone's estate. So get all of their affairs together, marshal all their assets, bank accounts, real property, all of that stuff, pay off any creditors' claims. And that's the point of publication. The point of publication is to let creditors know, hey, this person has passed, it's time for you to file your claims. Okay. All right? And after paying off those claims, then distributing. And distribution is either governed by what it says in the will, or if you don't have a will, governed by what the jurisdiction says, which is typically next of kin, closest kin. All right? So that's the general process is you got to file, you get the letters, you have to publicize, and then you have to pay off debts, and then you can manage the distribution process. What's really key is knowing that there is a timeline from the court. And so whether or not someone has a will, there's a timeline that has to happen. So if somebody dies and they own a property, just because you've got the letters, you can sell the property while people are filing claims, but the money from the sale of that property can't be distributed until creditors are paid off who filed in that case. All right. But you can sell a property. In order to sell that property, though, you need that letter of administration. Okay.
And you said there's a certain amount of time frame. How much time frame does the court give? And we have some questions coming in, and we'll get to it shortly.
Oh, good. So generally speaking, as a general matter of practice, 6 months after the letters are issued. So you can't distribute in terms of inheritances until about 6 months later. So I try to tell people that once you started the probate process, you're looking at least a 9 month process that you're going to be involved in. And if there's issues between family members and all that kind of stuff, you're looking at 1 year, 2 year. I got a case that's going on 3 years. Because people can argue and people come out of the woodworks. You know, you'd be surprised how many kids people have, which you may not know until after they pass. So sometimes that happens. And then sometimes people are willing to accept that someone has kids. And so then you've got that gets litigated. And that all can happen before letters are administered. So until letters are administered, you can't do anything with that house.
Okay, awesome. That is good to know. Actually, that's what we're dealing with now. We just found out, Margaret, when there's a 9th child. Oh, you're up to 10 now.
Wow.
I think there's 8 or 9.
Okay, yeah. So
kids come out of the woodwork. When I just had a new client who came on, and she just found out that she has 2 additional brothers. She didn't find that out until after her father passed. So that's just the reality of the situation. Sometimes you do not know until someone has passed.
Okay, we have a great question that came in, but how long do creditors have to respond to the claim for the money owed?
Right, so that 6-month period, if they don't file in that 6 months, their claim is forever barred.
Oh, wow. And is that standard for all states, DC, Maryland, and Virginia?
It's a general timeline. Others, states, like, they change based on the jurisdiction, but as a general sort of matter, I tell people be prepared for a 6-month creditor's claim period. So it's a creditor's period, and if the creditor's period is over on June 22nd and someone files a claim June 23rd, you can opt not to pay it because by law it's legally barred.
Awesome. All right. And just as a reminder to everyone, please put your questions in the Q&A box and not in the chat box. We have another question from another attendee. What if you are a resident of Maryland and you have a property in DC and Maryland? How will that work as far as order with no will in place and 2 names on the deed? Why you gotta come up with the challenging questions, people? But that's a great question.
Excellent question. That's an excellent question. And it actually reminds me of like remember I told you there are certain terms that are important to know in the probate process. This brings up one of those terms that I was going to talk about, and that's something called ancillary administration. So when someone dies, the state in which they live, that's where their probate has to be opened. So if they were a Maryland resident, and they die in Maryland, but they own property in DC. In Maryland is where you open their probate. It has that process, the 6 months and all that kind of stuff. And then when you get, it's called a triple seal. So it's a certified copy of everything you filed in Maryland. You get that, and then you got to take it to DC and open what's called an ancillary estate, which means you have to open a probate estate in every jurisdiction where someone owned real property. So if they own property in DC, Virginia, Georgia, Illinois, South Dakota, you're going to DC, Virginia, Georgia, Illinois, and South Dakota to open what's called ancillary administrations. And you let the court, you give them the certified copy from the original jurisdiction, and then that time process restarts. So in DC, then you can get the letter for DC, but then that 6-month creditor period in DC starts. You go to different states. Now Georgia's a little different, so I really shouldn't have said Georgia. Georgia, you can sell real property without opening an ancillary administration. So you know someone who owns real property in Georgia, you got letters from Maryland, you're good. You can sell right there. But most states, now you have to go and open one in each jurisdiction. It's called an ancillary administration. And every time you open one, you got to start the time process over.
Wow.
So that's an excellent question.
Yeah.
Now, the second part of that question said 2 names on it, and it depends on how it's titled. If it's titled with a joint tenancy with rights of survivorship, then the other owner automatically gets the property. You don't have to go through court. But if it's tenants in common, then that means that the portion owned by the owner who died, that portion of the real property goes through court in order to be legally transferred.
Wow, this is great.
That brings back all those terms.
Yeah.
All those terms that we learned in real estate class.
Mm-hmm, mm-hmm. It's taking you back, isn't it? It's like nostalgia.
Yeah, but Shakisha, this is really great information you're sharing with us. So thank you so much. I really appreciate that.
You're welcome. That was a great question. I don't know if that person teaches on the side and writes essay questions for.
No, she's on my team. Tanya asked the question. Tanya Scott, she's on my team.
Tanya, you're a good exam question asker. You should
Yeah, I got a quick question if you don't mind.
Yeah.
So suppose some of this stuff happens like in the middle of a transaction. We usually write them out 30, 45 days at a max. What's the likelihood of a turnaround happening prior to closing date?
That's what we're dealing with now, Donnell, on one of our listings.
Well, so it depends. So it depends on so many factors, unfortunately. So for example, right now we're in a pandemic, and the court has severely reduced its staff. And so the timeline that the court could have worked on, so for example, DC is actually fairly good with issuing letters of administration. If you put in a proper petition and all that kind of stuff, you can get letters in 2 to 3 weeks. Now, you're looking at 2 to 3 months. Maryland is even worse. There's not anybody for the Maryland court on here, right? I have cases in front of you, so please don't judge me. But as someone who used to clerk in the Maryland courthouse in Prince George's County in Upper Marlboro, yeah, that takes a bit of time. So unfortunately, it all depends on what has been done by the time the person has passed. Like if a deed has already been sold and signed and notarized and recorded, then, you know, it's just a matter of those last things, like the transfer going through. That's one thing. But if there's signatures required, if there's legal authority that's needed to do any part of the transfer that's left, wherever you are in the process, you got to pause it, and somebody's got to get letters of administration. It's not automatically transferred. Now, again, if it's a husband and wife who owns a property, typically that's done in joint tenancy. So typically the spouse just gets legal authority because now the property belongs to them. So hopefully it's a husband and wife maybe, or a spouse or something like that. But yeah.
And when you say spouse, that means the person that was married to him, not the person that's with him, right?
Yes, and I'm glad you said that because I've had to deal with that as well. Someone died recently, their spouse, they weren't living with their spouse, but they never got divorced. They're living with someone else. And I'm like, well, you didn't have a will. So even though you were with someone else, your spouse gets to come in and have that.
Yeah, and the only reason why I brought it up because it happened to me with one of my clients. So that's why the situation, it comes up. So that's why I asked.
Yeah, so whenever I see if a couple is even if they're getting divorced or something like that, but if people's names are on a deed and you don't want somebody's name to be on that deed anymore, I'm like, hey, we need to quickly clear this. We need to clear this title. We need to get this taken care of because you'll go years down and forget that you didn't take somebody's name off.
But
nice nasty twice.
I know, just to make sure, all the properties, I ain't divorcing you. I'm getting everything. Just to be clear.
I'm Miss Bennett. I'm not in it.
Jamal, we need quick claim deed immediately.
I'm on it.
Okay, Margaret.
Tina said that she used to be a title processor, and this is her flashback of processing probate files. Yes. Listen.
So definitely one thing I want to cover is terminology, like what terminology that we as realtors or even the general public that we need to become familiar with so that, you know, we are knowledgeable in processing estate and probate files.
All right, I wrote down a couple of terms because I wanted to make sure that some of the ones that I think that people kind of skip over. So testate versus intestate. Intestate means no will. Testate means a will. All right. Another one that's important is personal representative, executor, administrator. All three of those mean the same thing. Okay. It's the person that is appointed to take care of someone's estate. So if someone says, I'm the executor, this says personal representative, it's the same thing. It's just different terminology that all means the same thing. I already talked about ancillary administration, which is those extra estates that you got to open in different ones. Attorney in fact. Attorney in fact is another word for your power of attorney. Most people don't know that. They're like, attorney in fact, so like your attorney? I'm like, no. Attorney in fact, which is someone appointed through a financial power, a durable power of attorney. All right. A codicil is an amendment to a will. CODICIL, codicil. Most people don't know that. Probate estate. It's important to know that there's a difference. So an estate is whatever someone owns, their assets is whatever they own at the time they pass. Probate estate is only those portion of their assets that has to go through court to transfer legal title. So sometimes for you guys, real estate agents, you know, you can have certain kind of deeds that transfer title without anybody needing to go to court. You can have transfer on death deeds, which is in DC and Virginia. And in Maryland, you can have what's called a life estate deed. And so that says that subject to my life, when I pass, my interest in this property goes to this individual. A properly executed life estate deed or transfer on death deed, those allow you to avoid that probate process. So if somebody comes to you and there's a properly recorded transfer on death deed, you don't have to send them to court to now decide what to do with the property because the property is now theirs.
Awesome. All right, that was great. Thank you. Because I always thought, I don't know if anyone else thought the same thing, but I thought personal representative and executor were two separate things, to be honest. So it's good to know it's the same thing. It's just if you want to be fancy or you don't want to be fancy, whichever way you decide.
It really depends, because depending on where people come from, they're all called different things. So in Maryland, it's called a personal representative. But, if you're in somewhere like Georgia, they might refer to it as an executor. If you're in Maine, they might refer to it as an administrator. But they're all doing the same thing. They're the person with the legal authority to act on behalf of someone who's passed their estate.
Awesome. Thank you so much. And we have two more questions. You ready, Ms. Shalene?
Ready.
Shakisha? Okay, this is from Tanya. Tanya, are you writing tests over there?
Lord.
The question is, if there is a right of survivorship, can you still will part of your ownership to someone else?
That's a great question.
Mm-hmm.
Here's the thing. I always tell people that even if you've got a deed that's got rights of survivorship, you should address what happens to real property in your will, because the other owner could die before you.
Oh, wow.
And if you haven't addressed it now the property is yours. And if you haven't addressed it in your will, now what happens to it? Right? So it may just mean that if you die first and you said this is what happens to the property, and the property has got rights of survivorship, the property is no longer yours at the time you pass. So that particular part of your will is just not enforceable. But you should address what happens to real property if you want something specific to happen to it, just in case you're the survivor. Because if you're the survivor, and then a lot of people don't update their wills as often as they should be updating them every year. So you should be prepared if you are the one who is the survivor. Awesome. So that's the answer to that question, but that's a good one.
Okay. We have another one from Miss Shalene. Thank you, Shalene. I'm glad you're getting a lot of information.
Good.
She's saying, if it is a tenants in common situation, does it mean the surviving owner must sell the property to satisfy the portion being given to the party who died, their family?
It depends. So let's say that you have, two owners, tenants in common, and one of the owners says that my portion goes to my two children. So that means that, once it all gets settled through the court, now you've got three owners. Here's the thing that could happen. What could happen is someone could force the sale of the property by filing the proper type of, it's a partition. So it's a motion to partition. And that anybody who's listed, it could be someone who's got 0.01% ownership of a property. They can file something that says, I don't want title of this. I actually just want my money. So I want it to be sold, and I want my portion to be paid out in cash. And the only way to avoid that then is to pay that portion, pay them their value in the property so that they can close the suit out. So we've definitely been in that situation before where, things pass down and there are like 5 or 6 owners and 5 people want to keep the property and one person doesn't. And so that one person got a lawyer and they filed a motion to partition. And in order to then keep the property, the other 5 owners had to buy out the person. So it all depends on kind of what the owners want to do. If you want to keep the property, you can. So it's not necessary to sell it, but you just recognize that the more owners you have on a property, well, you know what happens when there's too many chiefs in the village.
Sure.
It can get a little dicey there. So, and plus, you also remember that if there's more owners and then one of those owners passes, depending on what their will says, and then you just kind of have, the growing list of owners. And when it comes to properties that Black people owned in the South, all that land and everything like that, that's how a lot of land was lost, because people were just like, I don't want this Southern land, I just want the money. And people who wanted to keep the property they didn't have the capital to buy people out, and that property was forced to be sold.
Awesome. That was a great question.
Yeah, it was a good one. You guys are, whew, all right.
Actually,
All right.
Keisha, we'll give you a break and we'll go over to Jamar. Jamar, I have a question for you, right? So from a title company perspective, once everyone has, one of those individuals have gone through the estate and probate process, what paperwork do you need to complete the sale of a house?
Oh, sure. The first thing that we're going to look for are the letters of administration. That's the biggest thing in the beginning. From the title company perspective, when we have an estate sale, we want to know who's authorized to act on behalf of the estate. And the letters of administration show who the personal representative is and who's authorized to act on his behalf. So right away, that's the first document we're going to ask
can I stick a pin here, Jamar? It
Sure.
has to be an original letter of administration with a raised seal on it.
Hello?
Somebody copy.
Exactly.
Could you repeat what you just said? You guys were frozen for like 3 seconds.
Oh, sorry. I was saying that the letters of administration that Jamar is referring to, it has to be an original. And you know it's an original because it has a raised court seal on it. That's how we know that, like, you're not giving us some letter of administration that you copied and then wrote your name over and all that kind of stuff. It has to be an original letter of administration with the raised court seal.
Perfect. Yeah, once we receive the letters of administration, next thing we're going to see is the death certificate. Death certificate is the official proof of death. It has some helpful information on it. It has the deceased taxpayer ID number, for example. It has their marital status, which is important in many instances. We want to know if the person was single, divorced. If they were divorced, that's evidence that their tenancy might have been, severed throughout the process. So we want to see the death certificate. We want to take a look at the will. The will is important because it lets us know if there's anyone else out there that could claim some sort of interest in the property in the future. So, for example, if the deceased deceased made a will, and in the will it said, I want my daughter to take on my real property. And if my daughter can't have the real property, I'd like for my, my niece or my nephew to take on the real property. Those are 3 people right away that can assert an interest in the property that we're handling the sale for. So if I look in the will and I see that there's someone else out there, daughter, niece, nephew, we want to talk to that person or those people and have their consent in some way to move forward with selling the property to a third party. Last thing we want is to complete a sale, and then in 10 years we have a niece and nephew coming to the homeowner's door saying, the property was left to us back in 2010. So we're going to address anybody we see in the will, right away. Fourth thing we're going to look at is the estate case docket. We want to see if there are any claims made against the estate. If there are any claims being made, we'll make sure they get paid. Biggest claims normally is the mortgage company, which we're gonna pay them anyway. But sometimes there's some bills on there that we weren't expecting. Could be doctor's bills, or sometimes the comptroller will weigh in. So whoever's listed, we're gonna make sure they get paid. One thing that I'll suggest also for the estate process is for the personal representative to create a bank account for the estate. We've got to be real clear that once we complete the sale, those funds are going to be sent by wire or check payable to the estate with no exceptions. So it can't be sent to the PR, the personal representative, can't be sent to any heirs. Even if there's someone in the will, can't be, sent to any heirs. No one except the estate will get the funds, and with no exceptions. So as a suggestion, I would ask for the personal representative to early on, get a tax ID number for the estate, create a bank account, so that when it's time to disperse funds, we're not having a, debate about it, because it's one of those issues that's not even debatable. It's funds go to the estate period. So yeah, that's a suggestion I would make. But yeah, generally that's what we're going to request. Those are the documents I'll request from the title company perspective.
So Tamar, that is great information. I love that you shared that. So just as a recap, we as agents, if we're going out and meeting a seller who has an estate sale, you're saying that probably upfront we should be asking for the letter of administration, the bank account information for your estate, the estate case document. I guess that's something you will get in the background.
Yeah. So the list would be the letters of administration, the death certificate, the will, if there is one, and just confirm that they do have a bank account open. You don't necessarily need them to give you the account information, but confirm they have one open, that they understand the funds of the proceeds of the sale will go to the estate. Make sure they understand that piece. And yeah, the case docket we'll review during the title review process, and we'll report on that ourselves.
Yeah, and I guess even on the buy side too, as agents on the buy side, that's probably a good list of things that we should ask the listing agent if, or how far are they already in the process, and if they have those things before we even get in the contract with buyers on that as well.
That is a great point. So should we also get on the list side, should we also find out who the attorney is, if there's an attorney involved in the estate process?
Yeah, I think that's a way to streamline the process. It makes it easier. I actually, from the title company perspective, I'm pretty happy when there's an attorney representing the estate, because it makes it easier for me to get the documents that I need, and the attorney will know exactly what I'm talking about when we're making that request. So yeah, if there's an attorney involved, perfect. You want to get in touch with that person right away, link that person up with the title company, and things will proceed much more efficiently.
Gotcha. And do you need any trust documents, or the letter of administration is enough?
Any trust documents?
Like sometimes there are trust documents for the personal representative, or that's not necessary.
Yeah, they're the two aren't one and the same. So with the trust, that's a different entity. But yeah, when there's a trust conveying the property, we'll need the trust docs. But for the estate, just the estate documents.
Okay, thanks for clarifying. So we
Yeah,
have
with a properly executed trust, either the property might be in the trust already, and then you're dealing with a trustee. So that's not the probate process at all.
Gotcha.
So yes,
That's separate. Got it.
mm-hmm.
I'm updating my documents. So thank you guys also for providing clarity to me. I appreciate that. We have a question. I'm not sure if this is for Shakisha or Jamar. Do children and stepchildren have the same rights to a property for an estate sale?
It depends. Is there a will that gives them the same access, or the same inheritance? If there's not a will, then no. In the eyes of the law, stepchildren are not legally a decedent's children. So in order for a stepchild to inherit, they're going through the entire family before they get to stepchildren. They're going through children, parents, nieces, nephews, brothers, sisters, uncles, aunts, before they get to stepchildren. Stepchildren fall if there's not any blood, if there's not a will. But if there's a will, and the will designates, these are my 4 children, and 2 of those are legally biological, and 2 of them are stepchildren, you can give people equal inheritance, no matter their legal relationship to you, if it's through a properly executed will.
Awesome. Jamar, I think we got a question for you.
All right.
Why aren't the funds from the property sale kept in escrow by title or the broker? That's a great question.
From the title perspective, Maryland's a wet settlement state. So once we know who's authorized to act on behalf of the estate, The estate has the right to sell the property and receive the funds from the sale. Now, what happens once the estate has those funds, that's a bit of a process in itself. But from the title company perspective, we don't want to be holding proceeds of the sale for any longer than what we have to. Not just the proceeds of the sale, but all of the disbursements that are associated with the sale, from the payoffs to the commission to the taxes, the recording fees. We're going to be dispersing a file as soon as we receive funding authorization, and that includes the proceeds of the sale. So once we know who's authorized to act on behalf of the estate and we're comfortable there, those funds will be sent to the estate right away.
Okay, great. And we have another question that came in earlier, and I'm not sure if this is Shakisha or Jamar. They're asking who should verify that the submitted letters of administration are valid and have the correct language. Is that something the title company does or the real estate attorney? So who should be handling that? Who should we go to?
I think the title company, the answer is probably both. Both the estate attorney and the title company are gonna want to take a look at it. I know from our perspective, we're ultimately insuring the transaction for the buyer, lender, additional title insurance. So we're definitely making sure that all the documents being provided are legit and can be relied upon. So the title company is definitely going to be taking a look at those documents, and we're going to request them pretty early on in the process.
And like I said, it's really important that you get an original letter of administration. That's going to be the threshold thing. If it's original, it's more likely correct. But also, probate estates are all public information. So all you got to do is, if it's in Maryland, you can just do Maryland estate search. You put it in the decedent's name, and in the court docket, it'll say right at the top who the personal representative is. So you also have that information that's available to you that you can use to double check it just on your own.
Awesome. Shakisha, we have a direct question for you. Is it better to have a will or trust or both?
It depends. Sorry. It depends because it's all driven by what your desire is, what the person's desire is to do with their property. Now, when it comes to logistically, like I said, the probate is going to depend on a lot of factors that are outside of the control of anybody. Like the probate process is what the probate process is. So for a lot of people, they don't want someone to go through that probate process to be dependent on what the status of the court is and the timeline of the court and creditors and all that kind of stuff. And so they'll distribute it through a trust. But it really all depends on the goals of the person that's creating it. I think at the very base of it, you have to have a will. And then the decision about whether or not to also have a trust where you might put a property into a trust is really, like I said, going to depend on the goals of someone. If you want to quickly get it done, you can do it through a trust because the trust, once a property's in a trust, they immediately have the legal authority to be able to do that. Depending on what they want to do with the proceeds of the property or that kind of stuff. So there's so many factors that it depends on that I would just say have to have a will. Very base of it, have a will. And then whether or not a trust is going to be beneficial to how you handle a property, you should probably just talk about your specific situation with an estate planning attorney who can tell you whether or not you need a trust to do what you want to do with the property. So it all depends. Because like I said, you also have transfer on death deeds and life estate deeds, which can help to avoid the probate process. If the only goal is to get it to one person after you die, you may not need a trust to do that. But sometimes people have more complex goals.
And this leads me into a question. What are the common mistakes that a realtor should avoid in this process? What are some of the common mistakes you've encountered? Same thing for you, Jamar. That question is for you as well.
I wouldn't call them mistakes. I would just say a couple of misconceptions out there sometimes. For example, if a person has a power of attorney in place and they die, then you can't use that power of attorney anymore.
Right.
The power of attorney is done and the estate process takes over. Now the personal representative of the estate is in charge. So that's one thing. We talked about the funds. That's a big thing. I mean, I've had all-out debates at the table, about the funds, proceeds of the sale. I think it'd be helpful to, and you've already kind of mentioned this, but start the undertaking, the document collection undertaking early on. Once you go under contract, we're going to ask for these things and we'll get to the bottom of it. But you don't want any surprises. And earlier you start asking for those documents, the better off we'll be.
Mm-hmm.
And then another thing is the tenancies. Those tenancies mean something. And if the tenant by the entirety piece is the one I think that we dealt with recently. So if you own as husband and wife tenant by the entirety and you get divorced, then the tenancy is broken and now your tenant's in common, and half of each party's, someone passes away, then the estate comes in. Prior to that time as tenants by the entirety, if one person died, husband died, property goes to the wife dies, property goes to the husband. If you divorce and break your tenancy, now your tenant's in common, and it's going to be a lot more difficult to sell the house. So I think those are kind of the things that I've seen out there, a couple just misconceptions.
And I would piggyback off of that last one, which is to know that if a property is owned by tenancy in common and one person dies, you need to go through the probate process. So, there's no automatic sort of transfer when it comes to one of the owners of a property that's owned by tenancy in common, of being able to avoid that process. So you really want to know, like, how is the property held first to know then kind of what the next steps are. And I think another one, I had it in my head. I can't remember right now, but the stuff that Jamar was saying, I was nodding along. Those are pretty much a lot of the common ones. And we talked about them kind of like as we've been talking today, but oh yes, that's the one. As real estate agents, protect your business. And so protecting your business means making sure that someone, if they say that they have the legal authority to do something after someone has died, ask them for an original letter of administration to protect yourself, such that if something happens down the line, you're not held liable because you didn't do your due diligence.
Okay, that's a great answer. Thank you. Yeah, because they love to throw us under the bus, don't they?
Hey, look, when you're dealing with people who are handling things for people who've died, people are they're in a very stressful situation. And so you want to make sure that you kind of set yourself to be seen as someone who is competent and knows kind of what's going on and the things that they'll need. Because I always think of it like, the more knowledgeable I am and the easier I can make the process for a client, the better it is for the both of us. So if I know that at some point they're going to need to have original letters of administration to finish the process, I'm going to ask at the beginning, well, not me, because I'm the one that helps them get it. But I'm saying if I were you guys, I would ask at the beginning, because then I try to minimize the amount of times that I have to ask a client for something, because it adds stress to an already stressful process.
Yeah, great. And we have another question coming in that says, if your name is payable on death on a checking account, will that be okay for the funds transfer for the estate? They want that money right away. They both shaking their head like, no.
No, unfortunately,
Sorry.
yeah, it's not gonna work. I've seen checking accounts that names who the personal representative is. That's fine. So say it's estate of Jamar Patterson, comma personal representative Liselle Taylor, or something like that. We could work with that, but that estate has to be front and center. That's the most important piece.
Here's the thing that people don't know about the estate process is in the probate process, the reason why it's so important to have an estate account is because the court, whenever you're paying out debts of the estate, it comes out of the estate account. And depending on what jurisdiction you're in, the court is going to require that you submit bank statements. And so, if someone is commingling their personal funds with estate funds, then they're going to be submitting their personal bank statements to the court. And so I try to tell people, look, you want to keep it as clean as possible because you've got to provide the court with an accounting that says, here's what happened to every dollar in this person's estate since they died. And so if I'm commingling, that means that when I ask you for the bank statements in order to prepare that paperwork for you, I'm like, okay, well, now I see what you spent all your personal money on. I just had to do that from somebody. And I'm like, wow, you really go to Costco a lot, don't you? You know, I don't want to know that much about you. I don't care what you do with your personal money. What's going to get you held liable if you're not doing it properly is what you do with that estate funds. And so if you're not handling those estate funds properly, the court's not taking your word for it. The court wants to see paperwork that says, oh, the proceeds from the sale of the house was $50,000 and each of these people was supposed to get $10,000. Where's the check? Where's the paper trail that says that they got that $10,000? So you're helping them again, because you know coming down the line, those questions are going to come from the court. Jamar is not putting himself in the line of fire for somebody who decides to just throw money wherever they feel like throwing money. And neither am I. And neither should any of you.
That's a great question. We have another one. Do you need to execute a will in order to leave a loved one a life estate to the home? Meaning, if you pass before them, they are allowed to live in the home until they also pass before the house is passed to another family member.
So one of the things I try to tell people is that the power of a will is limited. Mm-hmm. And so there are people who have so remember I talked about the difference between a will and a trust is depending on what your goals are. If you have long-term goals related to what you want to happen with a property, in order to properly make sure that that's done, you're using a trust to do that. When you submit a will to a court, the whole goal of the court is to collect their probate fees, make sure you did what you were supposed to do, and get out. Even though it takes a long time, that's their goal. They don't want to hold this. So if a will is like, for the next 5 years, somebody gets to do this, and then after that, it gets transferred. That means that the court is supposed to be enforcing a will for, you know, things that are supposed to be like 20, 30 years down the line. The court's not doing that. And so you want to be careful because you can put unenforceable provisions into a will, and then, you know, you're just kind of stuck with that. So you really want to sit down. If somebody has long-term goals, they want to sit down with an estate planner and they want to find out what is the proper way to make sure that that can be enforced, because everything can't be enforced through a will. Some people will write, here's what happens to my life insurance, and they put it in their will, but their life insurance has beneficiaries named. Your will is not controlling their life insurance. So you got to be careful.
Okay. Another question that came in, and I can see people have a lot of personal experiences with these estates.
I know they do. I know y'all do.
I mean,
I know y'all do.
And our situation is special in that the husband and ex-wife, they still own the house together. But they got it was crazy. So this is actually a great question. The person named in the will as the inheritor of the property and is also the executor of the estate. Can they transfer that property to themselves and sell the property outside the estate?
Oh, yeah. So if someone is supposed to inherit the property, go through the probate estate process, and once you get to the point where you can make distributions, if there's not creditors' claims that require the sale of the house to cover it and all that kind of stuff, then the executor, personal representative, administrator, whatever, can, transfer title to themselves as an individual. And now it's their own property and they can do whatever they want with it.
Okay. I didn't expect that answer, but okay. That's great information.
You just have to go through the process.
Okay.
As long as they go through the process, you're legally covered, because the thing that people think is like, oh, okay, well, I'm the executor and I'm the person that gets the house. Why do I need to go through the process? Because people die owing people money, and those claims have to be satisfied. And there are times when the only asset someone has is the house. Mm-hmm. So you can say so-and-so gets the house through my will, but if your outstanding medical bills requires the sale of the house in order to satisfy that debt, then whoever you said gets the house, unless they're paying that medical bill from their own money in order to get the house, it has to be sold. So yeah, that's why the legal process has to take place.
Especially the publicizing that this is what's going on. Okay, got
Yes.
it. That has to happen no matter what.
Oh yeah, the court requires proof that you've publicized it. So yeah.
Okay. And publicizing meaning they're looking for newspaper articles. Is
Yep.
social media, does social media count for publicizing?
Nope.
I had to ask.
That's a good question.
No, but that was a good one. That was a good one. Nope. They got it. They want to see an invoice. They want to see a copy of an ad. Yep.
But I have a timeline feed on Facebook and Instagram. I mean,
Give it 10 more years. I think
Give it 10 more
Facebook
years.
ads might count.
okay.
Right.
So quick question. Just say that the debt is more than a house and you under contract. So really the debt can take the house and then your buyer can't purchase the house.
Yeah.
Okay.
You can definitely be in that situation. So what that's called is it's called an insolvent estate. It means that the debts of the person who died is greater than the assets of the person who died. It doesn't make the personal representative liable for those debts. It simply means that they sold the assets, they liquidated all of the assets. They paid as much of the debts as possible. The court has a priority order for debts. And once there's no more money in the estate, the personal representative lets the court know that the estate is insolvent, and that's all she wrote.
Okay. Thanks.
So a follow-up question was, so you just can't collect and transfer the property without notifying others of the estate, correct? She froze.
Through the estate process. The estate process requires publication.
Yeah, which does not include social media.
No. Like Tamar said, give it another decade, and we'll see where the court is. But if there is any entity in the United States that moves slowly, it is the legal field. So it might be 2 or 3 decades before we get to social media.
We have another great question. What if you're a married real estate agent with an LLC or S Corp with real estate investments in agent name only? Is a trust required for those assets, or a trust with all assets of both husband and wife required?
Okay, say it one more time so I can make sure I get it right.
Sure. You're a married real estate agent with an LLC or an S Corp. With the investments, the real estate investments, it's only in the agent's name only. So she wants to know, is the trust required just for those assets, or she has to do a trust with both her husband and wife, in both the names of the husband and wife?
Okay, I'm going to try and answer this a little bit more generally. So if a home is in an individual person's name, and that person dies, what happens with that home has to go through the probate process. There are things that person can do to avoid the probate process, and one of those is using a trust. And so if someone can transfer the title of a property from them as an individual to a trust with them listed as a trustee, right? And so if that happens, you can use that trust to then avoid the probate process, and what happens to the property depends on what you've listed in the trust. As it relates to jointly owned property, there are trusts where there are joint owners. So spouses can create a joint trust where they then put joint property into that trust. Or if an individual has a trust and a property that they own with someone else, both of them sign that into their trust, then they're the controller of what happens to that property. So I'm hoping I got all of that. I had to open the Q&A to
does
try to follow on.
any of that process change if that property is in the LLC or in the S Corp name?
Yeah, so okay, if a property is an LLC name, if it's under an S Corp, so if it's under a business entity, then what should happen is, hopefully, prayerfully, they've got an operating agreement which says what happens to the assets owned by that legal entity when someone passes. And so that is driven by that. Now, if you have an LLC or any sort of business entity where it's not addressed what happens to the assets owned by it. And that could be a bank account, it could be property, it could be furniture, all that kind of stuff. Then they're looking at the owner's will. And if not the owner's will, then you're engaging the probate process, and it depends on what the jurisdiction says. Because, I've had that issue. It wasn't real property, though. It was a bank account that was owned by an LLC, but there was no operating agreement that said what happened to the bank account, and the person died without a will. So Maryland said, well, this is what has to happen to their assets. But like trying to get it from the LLC into the estate process has been more than a notion. So if you know that someone has real property that's owned by a legal entity other than themselves, they need to have a legal document that says this is what happens to these things owned by this legal entity when the owner of the legal entity passes. Because a lot of people will overlook that. You want to find an operating agreement that addresses that.
That was good, because I guess a lot of people set up LLCs, and just, if you are setting up an LLC, make sure you got your operating agreement entitled to.
Please. Even if it's a single member LLC, especially if it's a single member LLC. At least if it's owned by multiple people, somebody in the multiple numbers will be like, we need to have an agreement about what happens. But especially if it's a single member LLC, you want to have an operating agreement that says what happens to the assets owned by the LLC when the owner passes.
Awesome. This is great information, Shakisha and Jamar. Thank you. We appreciate you. Of course, we have more questions coming in. So if an owner does have the home deeded in a trust and that owner dies, then does that excuse the deceased owner from going through the probate process?
Yep.
Okay, because it's in a trust.
Yep.
Great. And we have another one. What happens if the home, this is a good one. What happens if the home has a reverse mortgage and the sole owner dies with or without a will? Got a reverse mortgage.
The reverse mortgage, as a practical matter, will be treated just like any other mortgage.
Yep.
So it doesn't change too much. I will say, just from experience, for some reason, reverse mortgage payoffs are difficult to obtain, and they take probably 3-4 times as long to obtain a payoff. So this is a practical matter. If a person passes, we'll look to see who the personal representative is. We'll find out about their mortgage. We'll attempt to get a payoff. And normally we'll get a payoff in, say, 3 to 5 days, and we can let the personal representative know overall what their bottom line's looking like for the transaction. Reverse mortgage, it might be 3-4 weeks. They ask for a lot of documentation. They want to see death certificates. They want to see all sorts of documentation before releasing the payoff. Now, from my perspective, if somebody owes me money and you ask me for a payoff, I'll give it to you the same day. So I'm always taken aback by how long the reverse mortgage takes. But just to answer the question, it doesn't change the process too much. We're still going to pay the mortgage off in full as a part of the settlement.
Awesome. That's a great question.
Mm-hmm.
Margaret, I know you had a question you wanted to ask, but did it get answered throughout the conversation?
A lot of my questions got answered, but I did have, I guess, more of a general question. Well, two questions. So the first question, which I think has been answered overall, is that essentially everyone needs to be doing some sort of estate planning. It seems like a lot of people, even feedback from clients, is just like, well, I'm not rich, I don't need to do that. So can you just kind of hone in on like the importance or the logical way that people would go about that if they don't have a great amount of wealth?
So that's a really great.
We're losing you, Shakisha.
And the reality of it. Oh, can you guys not hear me?
We can hear you now. We're good.
Oh, okay. So that's the question I get a lot. And the reality of the situation is that these jurisdictions, the legal entities, the governments, the powers that be, don't care if you have $1 to your name, $1,000 to your name, $1 million to your name. If it's in your name alone, they're going to make you go through the probate process in order to get it. If you don't have any estate planning documents. So I tell people, if you're 18 At the very base of it, you should have 3 estate planning documents. You should have a financial power of attorney, you should have a healthcare power of attorney, and you should have a will. Financial power of attorney and healthcare power of attorney help you while you're living. And it makes sure that if you become incapacitated or disabled, you can't manage your affairs, you're unavailable to manage your affairs, there's somebody who can act on your behalf, and you've guided them as to what they should do. If you, and when you pass, your will comes into place. Like Jamar rightfully said, people will come to us with a power of attorney and say someone's died and I'm their power of attorney. And I'm like, you're not their power of attorney, because if they're not living, they don't have, you don't have any legal authority. Okay. So if you have anything that is legally titled in your name, in order for it to be legally titled in anybody else's name, there's got to be some sort of legal transfer. And there's a couple different ways that you can do it. For some people, I try to tell them, well, hey, you know, if you feel like a lot of what you have is not worth a lot, which I hate when people say that, because you can take a little and turn it into a lot if you're intentional about the way you use it. Then I would make sure that things like, while you're waiting to finish your estate plan, things that you want to make sure you have in place is having a payable on death beneficiary on your bank accounts. It is making sure that your life insurance and your retirement accounts have beneficiaries listed who are living. That's a big one. I just talked to someone today who her life insurance beneficiaries are her parents who died 20 years ago. And so I said, if you don't take care of that, then when you die, that life insurance is going to go through the probate process. It needs to have someone living at the time you pass listed as a beneficiary. If you have a car in the state of Maryland, you can do a transfer on death designation with a vehicle car title. You know, there's a number of things that you can do if you feel like you don't have a lot to spread around, but not doing anything means that even with the small amount that you say you have, then that means that it becomes so difficult for people to get access to it that in a lot of instances, they'll leave it alone. So for example, there was a $5,000 bank account. This person died with like 4 or 5 children, didn't have a will, and the amount that it would take in court fees, legal fees, and everything to get access to that bank account meant that the family was like, oh, that's just too much to deal with. And so that $5,000 just went unclaimed. It just went unclaimed. So it doesn't matter how much you think you own. If there's something that's legally titled in your name, you should have something that says that someone can act on your behalf. And when it comes to power of attorneys, it doesn't matter how much you own. It doesn't matter if you have $2 in the bank account. If you've got a bank account that your income comes into, someone can't access that account unless they've got a power of attorney or unless they've been named by the court through your guardianship process. So it's really, really important for everyone above the age of 18 to have estate planning documents, because you inevitably have at least one thing that is solely titled in your name.
And when you say unclaimed, that means the state just get it, and the state end up keeping that money that could have went to one of your loved ones or
Absolutely.
someone in your family.
Absolutely. Yep. It goes into Maryland's unclaimed property.
Wow.
Awesome. Thank you. And then another question that I think comes up for a lot of people at a certain point is knowing how to break the ice, especially with parents. So when you have your parents get to a certain age, knowing how to ask the questions of whether you have a will, whether you have a POA, where is it? How do I find it? What's your advance medical directive? How do people kind of navigate that in a way that's not
Like I'm thinking about your money already.
like I'm waiting for you to die?
I'm
Exactly.
waiting for you to die so I can get your money.
Yeah.
Right.
You know, it's such a unique conversation to have with people. As an estate planner, you know, I'll be around Sunday dinner like, did you finish your will like I told you to do? Huh? You got your life insurance beneficiaries designated? Like, I'll be the one at dinner. Let me tell you, I am a hoot at parties. Like, I just be at a party like, girl, you told me you was going to talk to that lawyer about finishing your piece of work. Did you do it? But that's just me. What I tell people to do is, you know, you got to start with the relationship. If you don't have a close enough relationship with someone to talk to them about money, then it's probably not a close enough relationship to talk to them about their estate planning document.
Yeah.
So, you know, if you ain't talked to your mama in about 20 years, don't call your mama up talking about Mama, did you do your will? Because you don't have the proper relationship in place. Because if somebody did that to you, you'd be out here like, why you want to know what I did with right? So you want to start with having the right relationship. The other thing is it's a conversation like any other hard but necessary conversation that you have. Read the room, like if y'all are arguing with your spouse is not the time to be like, well, you know what? That's why I'm gonna change my will, because that's probably not the best time to have that conversation. But it's an intentional conversation that you have to have. When you're in a good place, you say, hey, I attended this webinar and I know that estate planning is something that needs to be done. When do you want to have a conversation about estate planning? And that's really it. And you decide when you're going to have that conversation. And if that person feels, a lot of fear related to it, because it's something that is difficult for people to do, to talk about their mortality, to talk about their incapacity, then you tell them, you know what? I know a law firm that does these free webinars. The only thing we're investing is time. And so for a lot of people, because there's so much fear around the process, there's a lot of disinformation out there. So just tell them to call the Griffin firm, sign up for a free webinar, get the information, and use that as a springboard to then have a conversation. That's what I tell people. And like any other hard but necessary conversation, like Nike, you just got to do it. You know what I mean?
Yeah.
Awesome.
Yeah. And also someone just shared, if you could please explain the importance of letting your loved ones know where your will, power of attorney, etc. can be found in the event of your death. So I guess that's back to the relationship again.
Yes. And then now as it relates to a will, you can file a will. Whatever county you live in, wherever your jurisdiction that you live in, you can go to your local courthouse and you can file your will for $5, one-time fee.
Oh, wow.
And then that way, whenever anybody goes to open your probate estate, oh, we can't find Shakisha's will, I'll just go open it and, I want to be the personal representative. But when they open it, the court file triggers that 20 years prior, I had filed my will. And they go, you're not named as a personal representative. So-and-so is. So, yeah, if you've got a will, file it. Doesn't hurt.
Got it. Okay. That answers all of our questions so far. Does anyone else have any more questions? I mean, Shakisha, this was a wealth of information. We just have one more that came through. What happens if you have a joint savings account and one person dies? Do the courts have the right to take one half of the funds?
Nope. Joint savings account, one owner dies, the other owner becomes the sole owner.
Okay.
And that's for any savings account, checking account, any type of bank account where there's two owners. When one owner dies, it just becomes the other owner's money, which is why I tell people to be careful about joint bank account owners, because, you give people access to your money.
No.
I don't like giving people ownership over my money. That's why I'll own the account and I'll have a POA, which will give you access to the account, but you gotta use the money for me. But if I give you joint ownership, then that means that's your money too. You get to use it the way you want. Not on my watch, but I'm an estate planner, so.
Gotcha. And someone wants to know, should you use a lawyer or family member as an executor?
It all depends. Again, it's about relationship. If your closest relationship is with an attorney you trust, then you can choose the attorney recognizing that your estate is going to pay that attorney to be your personal representative. You can, and outside of family members, you can also choose friends. If your friend of 20 years is the person you trust most to handle your estate, then name them as your personal representative. It does not have to be a family member.
Awesome. And someone just asked, which is a great question, how difficult is it to change your will after it's been filed?
Not
difficult
at all. Remember I said codicils? That's one of the you can do a codicil with any attorney. It's just that once you do that codicil, you want to file that wherever you filed your will. So it's just whenever you update your will, you just make sure to go back and update the court file with the most recent documents. But filing your will, changing your will is a fairly easy process. It's just a matter of executing a new one. That's it.
All right. And someone wants to know where the free webinars you just mentioned about how to have those conversations, where can they go for those webinars?
Oh, so our website is your estateplanningattorney.com. And if you go on your www.yourestateplanningattorney.com, and then if you, there's a link at the top called schedule your appointment. And once you click that, it tells you about all the free webinars and the dates and times, and you can just sign up that way. And if you want to talk to a person, then you can call the office 202-379-4738. But yeah, we do those free webinars all the time. I think my next one is probably next week, I think.
All right. Ms. Solomon just asked about your contact information, if you just want to share it, but I also posted her and Jamar's contact information in the chat group. I'll repost it again, but if you just want to share with us the best way to get in contact with you, Shakisha.
Best way is email, because I'm an attorney and I don't know how to close my email. Got on my computer, got on my iPad. I really can't get away from it. So the best way is to email me. So my name, first name, Shakisha, SHAKISHA at the THE Griffin GRIFFIN firm FIRM PLLC.com. Shakisha at the Griffin firm PLLC.com. The best way again.
And also, everyone, when we send out the free webinar, we're going to have both Shakisha's and Jamar's information in the link that is emailed out. So, and it's also in the chat, and she just also shared with us. But otherwise, I thought this was great. Thank you. I learned a lot today. I really appreciate your time. So thank you. Anyone?
Yeah, appreciate you.
Yeah.
Thanks for doing this. I mean, honestly, when I saw that you were doing this, I was like, this is a really, really great resource. You probably want to do this on like a, I don't know, quarterly, yearly basis, just to refresh people for like updates in the law and all that kind of stuff. But, we're all working in the same community of people. Like when someone passes, we're all touching them in some way. So it's good for us to kind of have this community to be able to reach out to each other as resources. So thank you for having me.
Oh, thank you for your time. We appreciate it. And don't worry, everyone. Thank you, Jamar. We always love having you join us to share your information.
No problem. This was great.
Jamar's a celebrity.
Jamar's a celebrity.
I'm working every day to get there. Coming along.
And also the attendees who joined us, I thank you for your time. I really hope you guys learned a lot. We really appreciate you. And in the event, if you don't get the link, please send an email. You can reach us at info@taylormadeteam.net. And it's info@Taylor, TAYLORMADE team.net. And we'll make sure we get the recording out to you. But otherwise, everyone have an awesome day. And thank you so much again for joining us. Thank you, Shakisha. Thank you, Jamar. Thank you, Donna.
Yeah. Take it easy.
Everyone.
Bye.